Hi, everyone. This is Leica. As you know me, North Carolina State Director for On the Line. And as part of our redistricting leadership program, I have for you Marina Jenkins, who is the Litigation Director for the National Redistricting Foundation, which is an affiliate of On the Line and which was deeply involved in the redistricting cases that happened in 2019 that were so impactful. So I've asked her here today to just talk to her a little bit about what those cases were about, what it was like, and get some of her perspective on that because I think we're just really lucky to have her. So welcome, Marina. And yeah, we'll go ahead and get started. So how did this all come about? Like, what was going on in North Carolina in 2018, 2019 that like made this a good time? You know, what was in the background?
Sure. So there are sort of two things going on in the background that are important to understand about North Carolina at that point in time. One is that both the congressional map and the state legislative maps had been redrawn in 2016 and 2017 after having been struck down previously. And we can talk a little bit more about why that happened and the history there a little bit later. But so there were sort of newer maps, right? So when we were getting ready and preparing to file this case, the first case in 2018, you know, it had only been a year or so since the maps were instituted. So they were still relatively new. And then you also had the background of what was happening in federal courts across the country, in North Carolina and across the country. And there was this moment where, you know, I think a lot of people in the advocacy community, in the redistricting community, thought that maybe the federal court, the US Supreme Court, would finally, you know, strike down partisan gerrymandering. Mm-hmm. And so in the spring of 2018, we were waiting for the court to decide the case Gill v. Whitford, which was a case out of Wisconsin that was a partisan gerrymandering claim. They had been successful in the lower court, in the district court, and before a three-judge panel. So the three-judge panel in redistricting cases don't go directly to the US Supreme Court. And so the court below had decided that the Wisconsin maps were partisan gerrymanders in violation of federal law. And so now it was before the US Supreme Court. And so, you know, there were a lot of people who were sort of hoping that this would be, you know, a break the glass moment, a breakthrough moment for anti-gerrymandering efforts. Unfortunately, the Supreme Court sort of dodged the question, and they kicked down Gill on standing grounds, basically saying you can't make a statewide argument, it has to be a district by district argument. But as we were analyzing that case and that decision, it did seem like the writing was on the wall that federal court was not going to be the path. And the other thing that you had happening was in Pennsylvania, a case had been brought in state court and that was successful and that struck down under the state constitution the congressional maps as partisan gerrymanders. And so North Carolina has a similar provision to Pennsylvania that we thought would allow us to sort of make similar types of claims as to what was happening, what had happened in Pennsylvania. So sort of this, like, the legal landscape was shifting a little bit, that created a moment of focus on, you know, here's a state, North Carolina, with a history of, you know, problems around redistricting, obviously. But that had these constitutional provisions in the state constitution that might be a path where you know, federal court might not be the right way to go. Now, at the same time as, you know, the Supreme Court was considering Gill, there was a case moving in federal court, a pair of cases actually moving in federal court out of North Carolina. And those had been brought by, you know, a couple different groups of plaintiffs and organizations, but ended up with the sort of primary name of Common Cause v. Rucho, or then when it gets to the US Supreme Court, Rucho v. Common Cause. And so there was a challenge to the congressional maps that was sort of working its way up the federal courts at the same time that we heard Gill. So as we were contemplating this, you know, it sort of narrowed the focus not only on North Carolina in state court, but on the state legislative map first, because the congressional maps were already in court in federal court and working their way up. And as we would later learn, would be sort of the lead case in the US Supreme Court for 2019.
Okay, that's interesting. I didn't realize that that was sort of the thing that determined the choice to sue on the state legislative maps. I want to go back to something you were saying earlier, though. You were talking about how the choice to do this in state court in North Carolina was partly because there were good provisions in state law, like in the state constitution, that would sort of allow this kind of challenge. What were those?
So the North Carolina Constitution has a clause that we call the Free Elections Clause, and it seeks free and fair elections. And that's something that the US Constitution doesn't have. And so what happens in a lot of states that have sort of analogous provisions to the US Constitution is that the state courts will sort of follow what the Supreme Court or what federal courts have said about what that provision means and what it requires. So not only were we looking at states where their courts interpret provisions that have analogs to the federal Constitution and see if they maybe don't go lockstep with federal court, right? If they're willing to sort of see beyond the boundaries of that federal courts have set, but then also if there are other different provisions. So the Free Elections Clause is precisely that. It's a provision that doesn't have, an analogous match in the federal Constitution. So you're not going to be bound by what federal courts or what the US Supreme Court says it should mean. And so North Carolina state courts are allowed to, judges are free to, interpret that as they want and as they have. And so, and it's the same kind of provision that was in the Pennsylvania Constitution, or that is in the Pennsylvania Constitution, that was used as a path toward a finding of excessive partisan gerrymandering that violated the Constitution. And so when you go back into sort of like the constitutional history, of the Pennsylvania Constitution and the North Carolina Constitution, are developed at the same time in history. They're sort of have the same sort of principles. They have a lot of the same deep history. And so naturally, then you should, the sort of natural conclusion is that they should also be interpreted alike. And so that was sort of the path of trying to identify that provision and sort of, and needing to have free and fair elections that, translate the will of the people is sort of the basis of the interpretation that we were seeking and that we were successful in achieving.
Yeah, and just to specifically reference my understanding, this is the part of the state constitution that just says all elections shall be free, something like that.
Yes, thank you.
No, just because it's something that we've mentioned in previous lessons, so just to reference there so people remember. So you've talked a little bit about why this was an opportune place in North Carolina because of these provisions and why it was an opportune time. How specifically did the NRF, did the National Redistricting Foundation get involved in this Common Cause versus Lewis case, which is the state legislative case?
Yeah, so our organization is, we support and develop cases. So our role in the litigation is to sort of identify the legal issue and then sort of build the case. So we sort of identify the legal issue, collaborate with a legal team, and then identify plaintiffs. And so as we started sort of talking to folks in state, trying to see who was thinking about this, anybody else looking into this, towards the end of the summer in 2018, we ended up having a conversation with Common Cause and learned that they were also sort of thinking about these issues and looking into this issue. And so we had a series of conversations and then ended up deciding, let's team up, let's do this together. And so Common Cause and a group of individual voter plaintiffs became the plaintiff group. And then the foundation, supports the litigation financially and strategically as the case goes forward.
Okay. No, that's super interesting. Just to kind of go back again, so you get involved in this case and you're using sort of especially other provisions in state constitution, but especially this free elections provision is sort of the unique element. So what argument are you actually making in court? How are you saying this all elections shall be free translates to there shouldn't be partisan gerrymandering.
Sure. I think the argument really is about whether or not the will of the voters can be realized. And so, a main source of argument is that we pursued in North Carolina is there was, what we sort of called a seawall, right? There was this built-in structural advantage for Republicans that was able to withstand even, you couldn't even get, Democratic voters could not sort of elect candidates and representatives to reach a sort of comparable threshold to their voting power because there was this structural advantage that was built in. So for example, you'd get sort of so far over 50, you would need, Democrats would need so far over 50% to get to an actual, majority in the state legislature. And in some instances, it would be even, sort of impossible for them to do it. And ultimately that was the conclusion that the court reached in finding in our favor, was that, it was basically, this system had been built so that it was impossible for Democrats to ever reach a majority and very, very difficult to even break a supermajority. And so, when you see that structural disadvantage, and we had a series of experts sort of speak to, this seawall, as they were calling it, and just how strong it was, and sort of no matter the wave of in favor of Democrats, the Republican seats were just safe. And so, it was that kind of evidence and that kind of argument that ultimately concluded that those are not free elections, because you're not actually able to communicate votes and translate those into legislative allocation of power.
Mm-hmm. Yeah. So again, I'd love to dig into that a little bit more, just like the kinds of evidence that were used, because I know that a lot of the sort of disputes about partisan gerrymandering in the past have been about how hard it is to actually quantify it and how hard it is to demonstrate it. So what were some of the methods that were used by the experts in the case to show that it was real?
Yeah, this kind of case is very expert heavy. So we had 4 experts that worked with us and that did, 3 that did sort of really, trying to quantify the problem. And then our 4th expert who gave, more of a historical perspective on, voting patterns in North Carolina and different the political history of various regions. So we had the 3 experts who were trying to quantify this problem, and they did it in a few different sort of different nuanced ways. But ultimately, the major evidence that we used was what's called outlier analysis. And so these experts are able to run simulations, and they sort of create an algorithm that would produce a neutral map. And so they create an algorithm using sort of traditional redistricting criteria, and they sort of have their computer run it, thousands of times. Even, I think one of the experts, like, they can run it like 1 million times. And then they just show that, they sort of use all of these simulations, and they show in these simulations the chance that just by natural chance, using neutral criteria, you would end up with a map that is so skewed, is just so minimal, right? So that, like, there has to be some explanation that is not neutral that has resulted in this map and in this partisan breakdown. And so, that's when you sort of, the argument you make is that the current map is an extreme outlier of what you would expect to see if you drew the map 1,000 times, if you drew it thousands of times using neutral criteria. So we had an excellent team of experts, including Professor Mattingly from Duke, who's the head of the math department there. So, these are just really powerful brains and just the smartest folks on these issues. being able to say, listen, there is no reasonable explanation for how these maps ended up this way.
Yeah, and I mean, I know that this has been like a significant interest of a lot of academics, especially in North Carolina, for obvious reasons. But I just wanted to also point out, so one of the other experts was Dr. Joey Chen, who also did like a lot of these simulations. And so I know that there was a lot of talk about like Chen maps during the map drawing process. And so just to give people a little bit of reference, that's what it was. So he was one of the people who did all of these like thousands of simulated maps based on some neutral redistricting process, like redistricting criteria like contiguity and compactness and, you know, like keeping municipalities together, things like that, that don't really have like a particular intentional political lean. So yeah, so that we'll talk about that a little bit more later when we get like a little bit further into the sort of discussion about the timeline of the trial. But that's for people for reference. That's what they were talking about when legislators were talking about like Chen maps. So obviously you have these experts giving these really great sort of quantifiable methods, sort of operating from the outside, just sort of looking at the maps and what comes out of them. But obviously also one of the huge like bombshells of the case was this these maps, this data from Dr. Hoffler, who was the consultant who had been hired by the legislature to draw the maps in the first place. So obviously, you know, maybe there was some perspective on like what was he actually doing, you know, not just being able to analyze it after the fact, but sort of having some insight into what was happening during the actual drawing process. So what were some of the things that were learned from like the files that were used in the case?
Yeah, the discovery of the Hoffler files, as we have come to call them, was, I mean, that was just, it was a real breakthrough in the case. Obviously, it was hugely, you know, interesting and newsworthy at the time, just because, you know, here is this expert, this, you know, architect of red map, you know, who had been known for, you know, I think slide presentations of like, you know, don't save anything, don't put anything in writing, you know, leave no trail. And here we, you know, sort of discovered his entire trail for decades. And so it was really helpful to understand the timing of when he drew the maps, and then just the inputs that went into them, and then the kind of analysis that he was conducting. And so the timing was really important because for sort of a slightly separate reason that wasn't directly addressed in the case, you know, so it wasn't sort of directly relevant, but was very important in terms of, you know, just the amount of legitimacy lent to the legislature. And so, you know, just to sort of rewind a little bit, I mentioned at the beginning that that these maps were new, and they were drawn in 2017 after the prior maps had been struck down as being racial gerrymanders. And so, you know, the legislature is already in this position where they've passed maps, they've enacted maps that were unconstitutional under the US Constitution and were struck down. And then in 2017, we're in a position to have to introduce and pass new maps. Now, in front of a federal court at that time, the same legislative defendants had represented that there was not enough time to draw new maps, and that they needed to go forward, and the 2018 election needed to continue to happen on the old unconstitutional maps because they couldn't introduce them. They couldn't introduce new maps. And so, so the problem at that point is that the court sort of accepted this presentation, this representation as true. And then we discovered through Hoffler's files that actually they had been, you know, the maps were over 90% completed at the time they made that representation. So that representation was just false. And it allowed the Republicans in the legislature to maintain their supermajorities and you know, sort of override vetoes on super important issues in North Carolina that you know, really were illegitimate because they had lied to a federal court in order to keep those maps and keep those supermajorities. Mm-hmm. So that was one really, really important fact that came out of the data or his documents. The other important fact was that Dr. Hoffler, and recall, so the prior maps had been struck down as being racial gerrymanders, so they were supposed to draw the new maps without using race, but of course, as we discovered, he was looking at race as he was drawing these new maps. And then the third fact was, what kind of analysis was he doing? Obviously, he was doing partisan analysis. There were tables and tables and spreadsheets of, looking at the maps that he had drawn and looking at them through that partisan lens. And so it was just a series of really, so those three facts were just incredibly important in proving, the malintent of the legislature and, through the map drawer, and in what ended up passing as the new maps.
Yeah, I mean, honestly, I can personally remember having seen them and being really shocked, because at the time that the redraw happened in 2017, like I was volunteering and showing up at a lot of these redrawing, at a lot of the committee meetings and stuff like that. And I remember at the time there being this really, really, insistence on the part of the legislators who were running the process that there was going to be no use of racial data and that it was not a thing that they were going to do. And also personally, me thinking at the time was okay, well, obviously they've said their goal is a partisan gerrymander, and you can do a partisan gerrymander without racial data. So, okay, well, but then to find out from the files that it was clear that Hoffler had been looking at the racial data, that it was there, that was, available to him, and that it was not something he wasn't considering. Honestly, I found that really shocking, even though I think we know how kind of mendacious the legislators have been about this stuff. To me, right. Still, that was kind of, that was a big bombshell to me, that that they had still insisted on kind of doing that. So that's super, super interesting. So kind of going after that, the legislative record itself, the things that were said by the legislators in committee or in press conferences, like I said at the time, they were pretty clear about making it a partisan gerrymander to overcome these racial gerrymandering claims. So how was that kind of used in your case?
Yeah, I mean, you said it. They were open. They were proudly saying, these are not racial gerrymanders, these are partisan gerrymanders. Partisan gerrymandering is not illegal. And, they were saying this with the confidence and the belief that the federal claims on partisan gerrymandering were not going to be successful. And so, I think it was both sort of easy to sort of point to their intent because they just said it, but also, being able to take that next step and give the sort of quantified evidence as we just talked about. But absolutely. I mean, I think that there was a lot of chutzpah. I don't know what the right word is to use, in terms of, them saying, we know, okay, we're not going to look at race. This is a partisan gerrymander. This is all about partisan. And so, I think folks who have spent any amount of time thinking about redistricting and thinking about how our politics play out, and the sort of interrelationship between race and party, that is a big issue, and those two things overlay, particularly in the redistricting space, and sort of how we think about communities and how communities should be grouped or should be, put together or not put together, or how communities should not be split, right? So as you said, you can draw a partisan gerrymander without looking at race. They didn't need to look at race. And so, I think it was also that the fact that they did, that just made it, extra offensive. it just took it over the top, Yeah. Because we started from the point, as you say, where they were just saying, you have David Lewis saying, we're partisan gerrymandering. We're not doing racial gerrymandering. We're doing partisan.
Yeah. Well, and I think you kind of mentioned something that I try to bring up a lot, which is that in North Carolina, like racial gerrymandering and partisan gerrymandering are things that are like, they're not easily separable. And it was actually really interesting. So we had a previous webinar with a lot of the student activists from NCA&T, which had been split in one of these redrawings that happened mid-decade in 2016. And, you know, they were kind of saying like, well, you can say it's a partisan gerrymander, but this is the largest HBCU in the country and you're splitting it down the middle. Like, how does that not have racial implications? So yeah, like I think that that's such an important point, especially, I mean, just, you know, I'm from North Carolina. I know North Carolina, like here, it is especially salient.
Yeah, absolutely.
So sort of going into like the trial itself. So you have this situation where you have these experts with this really good quantitative data, these Hoffler files, which are, you know, which are revelatory. And then you have like these really obvious statements at the time from the legislators saying, like, we're doing a partisan gerrymander. That's the point. That's what we're trying to do. So what was going on in the trial in the courtroom? Like, what was the approach of both sides? Because it seems, I mean, it seems pretty clear, like on sort of the side that you were operating on, like, it's pretty clear what argument you were making. This is a clear partisan gerrymander, and here's where we're taking from the Constitution that that's not okay. It's not expressing the will of voters. Like, what was the strategy? What did it seem like the strategy was on the other side when there's clearly so much evidence that that's what happened?
It's a good question. And I think that it was twofold if I had to sort of boil it down. And the first was following in the footsteps of something that Chief Justice Roberts on the US Supreme Court had said in argument over the partisan gerrymandering cases in federal court, you know, referring to the social science as gobbledygook, right? And so there was, I think, one approach that was, you know, this is just a lot like these numbers. It's just very complicated. It's very confusing. They sort of just trying to do this aw shucks, like, you know, here, you know, they're trying to just make this super complicated and you can't understand it. And we can't really know that this stuff really means anything. You know, there was, you know, the lead attorney on the other side, at times, Tom Farr, who I know is a well-known person in North Carolina. You know, and he sort of tried to, there were moments where he's sort of doing this, like, you know, and he's a very, you know, obviously, you know, successful lawyer in his right, but trying to do a little bit of this, like, oh, you know, this is all very complicated, judges, and this is, you know, because there's a panel of 3 judges, you know, so this is, you know, this, I don't really get this, a lot of math, it's a lot of this, you know, and so I think there was that approach that was tried, and then there was just the, you know, more straightforward, you know, that this is within the right of the partisans, and this is, you know, this is, it's not the court's role to decide, you know, when it's too much. And so trying to take that same argument that was ultimately successful in federal court, that like, this is beyond the court's role and you guys shouldn't get involved here. And so, you know, I think that the second tact was maybe more successful than the first. I think the judges were not as amused by the idea that they could not understand the presentations. And, you know, I thought our experts did an excellent job of really making it palatable and user-friendly to someone who is not a math PhD. And so I think they did a really good job, and our legal team did an excellent job preparing them to, you know, to present in a really consumable way. But I think, you know, ultimately it was, I think the court was just ready to sort of understand it and really digest that material. So it was great. And we ended up, you know, it was a 2-week trial, and Joey Chen, as you mentioned, who was a very central figure in this case, was on the stand for 4 out of the 10.
Yeah, I remember that. And you know, in a way it was kind of shocking because, I mean, I think that he has this really clear, compelling evidence, charts that are pretty easy for people to see and interpret, and sort of keeping him up there for that long to me almost seemed counterproductive because, like, you know, he knows what he's talking about, and he is really well positioned to explain it to people. So yeah, it was really interesting.
Yeah, I agree. Oh yeah, well, I think that he was up there I think more of his time was from them than it was from our side, because they were just trying to break him down, and he would not be broken down, which was excellent. And he was, but that, yeah, it definitely became, he was like the crux of the case at that point.
Mm-hmm. Yeah, sort of the target is if they could somehow prove to people that it was too complicated what he was doing, then like that was sort of what they were. But
yeah,
personally, I think, yeah, he did a great job.
Yeah. No, and that, I mean, you raised the tables and the charts, and I was actually looking yesterday, and you can still, Mattingly had tweeted one of the sort of images that they put up, and it was like a little video, and it shows a bar graph, and it's very easy to understand, very easy to see, and it shows the bar graph, and then it shows how, and this is with respect to the congressional map, and so it was a little bit simpler, because it shows like how many, the seat share that you would expect based on the Democratic vote share, and it sort of shows how, like, the more Democratic votes the state gets, how that bar graph sort of shakes out. And you just can see that, like, the Democrats wouldn't even get to 4 congressional districts until Democrats had a 52% vote share. And so, and it's like an 8-second video, and it's, it's up on his Twitter. It's so easy to see. They did such a great job of just really making it plain and easily consumable for people.
Yeah. And I'm definitely going to try to share that video with people.
Okay.
Because it is really compelling, and you can kind of just see where, like, it hits a wall, there's just a wall that it can't, that, like, no matter how high the vote share is going, that, like, Democrats just can't get more seats. So, the court order came down, and the order for the redraw, and sort of like just on a like, emotional level, even, like, how was that for you and the other people who had been working on this case for so long?
Yeah, I mean, it was exciting. It was, I think the remedial phase was just such a different, it was difficult in its own and new and different ways, right? And so, getting to the decision that struck down the map was huge, and was like a year's worth of work, and was just really exciting. But we were also sort of simultaneously doing 2 things. So we got the decision in early September, and we were simultaneously, then heading into this remedial process over the state ledge map, and because now we're in a post-Rucho universe, so the congressional map was no longer in federal court, because the U.S. Constitution, the U.S. Supreme Court had said, that partisan gerrymandering is non-justiciable, and that the federal courts are not going to, get into these partisan weeds. And so that happened, a few weeks before we went to trial, and then we get this decision in early September, and we made the decision to pursue a state case against the congressional map, and while we're simultaneously, going into this remedial process. So it was just, it was a wild 3 months. You were there. You will recall. Yeah. And so, so trying to, and the other complicating factor about the state legislative map, as I imagine you've spoken to folks about, is the clustering. So, there are, you are limited in a remedial map, there were sort of limits in terms of, okay, we are allowed to sort of address these certain maps, and sort of how do you do that? And then there's also the process point. And the process point was really interesting, because the court instituted a series of rules, and they were sort of supposed to encourage transparency, supposed to encourage, public participation, supposed to sort of limit the ability for the legislators to do, to sort of to gerrymander.
Yeah.
And, but it was very interesting, because, and you'll recall, that the transparency didn't, they sort of streamed this room, the room now, the committee room, and there was the sort of computer in the middle of the room, but they still, like, you could just like watching, you could like still see them sort of doing things that they shouldn't be doing, or, you know, asking, you know, someone walk in a room and ask for a line to be drawn a particular way and walk out of the room. And so it was just sort of shocking that even under court order, even in this environment where people are, you know, paying close attention, these are being streamed, there was still, you know, this like politicians choosing their voters. Like you just saw it on display and they weren't hiding it.
In a way, it was kind of funny because I remember at the time, you know, people who were like just ordinary people who were watching the live streams and stuff were really kind of shocked by like the blatant, you know, they would just be like a group of legislators from a certain area crowded around the computer saying like, well, I want this precinct and I want this other precinct. And like, it, you know, just like sort of the bare like partisan nature of it was really surprising that they were sort of like just still doing that even though everyone could see. And I think something, you know, I remember like at the time a reporter tweeting about it and being like, well, this is what's always happening. You just never saw it before. And I was like, yeah, that's the reason why we need to see it, because people need to be shocked that this is going on.
Right.
But sort of coming back to like what you said, I mean, from my perspective, obviously the court had sort of asked for all these things to happen to like sort of increase the transparency of the process. And so we got a lot of, you know, from particular legislators being like, this is the most transparent process ever. And, you know, this is so great. And, you know, I think I have particular feelings about that because, you know, especially on the public input side, there were like no real public hearings. There was like one in Raleigh that most people in the state can't get to. But yeah, when you hear that, like when you heard that coming from legislators, what did that make you think?
You know, I think it's hard. I mean, it's a hard truth because even in the best case, if you have, you know, you put in the criteria that you think are going to be protective, and keep them from doing bad things and keep them from manipulating the process and manipulating the map, that they'll still do it. So like on the one hand, it's a little frustrating to see like, you know, you're maybe living up to the letter, but certainly not the spirit of what is happening right now. And so I do think, you know, generally, and it does sort of support a general concern that I always have, which is, you know, there's only so much we can do in terms of process to, you know, enforce a process that will be fair, but you also have to have fair results. and that sometimes, you know, that transparent, exactly as you're saying, sometimes sort of, and I think this was a problem too in the court's decision and the court's acceptance of the map that resulted, which was an improvement, but was certainly not, you know, didn't take us where we needed to go, is that, you know, transparency is not the same as meaningful public engagement, right? So like allowing yourselves to be videotaped while you're choosing your lines and then hoping that nobody's going to hold you accountable is not the same as actually inviting voters into this process in a meaningful way that allows them to speak to you and to speak to, you know, what should be the result of this process. And so, you know, I do think that it definitely highlighted for me that tension and the importance of advocating both for transparency and as a separate important factor that needs to be there is that meaningful public engagement.
Yeah, no, I think that that's a really, really excellent point because, you know, whenever the legislators are the prime drivers here, and I've heard legislators, you know, during the process, a lot of legislators said this, that like just having legislators involved in drawing the maps at all is an issue because there's just sort of this irresistible temptation for them. And they also, you know, have such a deep knowledge of the areas that they represent that they don't need to be looking at partisan data to tell exactly which precincts would be advantageous for them to have. So yeah, I think that that's really true, that like we were operating in a situation where there was somewhat more transparency, although a lot was still happening behind closed doors, but that the legislators were still the prime drivers here, and the, you know, the people who they were representing really were not involved or engaged in the process in any meaningful way, and that is probably where the best interests of the people lies, for like that to be the driving factor, is for people to be talking about what they actually want to see for their communities, what actually makes sense to them. So that was really interesting. So obviously we had these redrawn maps, which were, just to go back to something that I mentioned earlier, we had these redrawn maps, which, at the time, one of the big controversies was what base maps they were going to use. And so I referenced the Chen maps earlier, which were these maps created by these simulations, and that was sort of what they chose to work from. I just would love for you to talk through, like, why is that an issue? Like, what are the disadvantages of using those simulation maps? And also, like, what happened to them afterwards? Because obviously we didn't end up with super neutral maps. That's just sort of a fact.
Yeah. So the idea of needing a base map is sort of the first step in this sort of thought process, right? And so a lot of times court drawn maps specifically will sort of try and just take the map as is and then make adjustments, right? But when you do that and you're sort of preserving the old maps in a way that sort of tinkers around the edges, but ultimately is sort of like keeps in place the gerrymandering that was done in prior cycles, right? And so we see this over time, and I think it's hard because in a lot of situations, legislators will say, like, well, we have to, preserve the core of the existing maps. And it's like, well, if the existing maps were gerrymandered, we should not be preserving those maps. But the court did want something to work off of. And I think the legislators, were sort of saying, we can't just simply start from scratch. We have to have something. And so they presented the idea of using Chen maps as sort of the base, and then just randomly picking a map, and or it wasn't totally random, but the sort of within certain scores of compactness, and that they were going to pick one of these Chen maps. And I think there's a real tension here, and we really struggled with it at the time to try and communicate to the court, like, this is not the purpose of these maps. The purpose of these maps is to evidence when an existing map is just outside the realm of sort of neutral, right? And so when it is an outlier, but that's a different analysis and serves a different purpose than having a map that actually reflects the communities in North Carolina in a meaningful and, responsible way, that actually, takes into account some of these important things. I think there's generally, some energy behind this idea that, like, eventually we can just have computer simulated maps, and then it's fair because nobody gets to complain that they're being they're being discriminated against because a computer chose it, right? But which sort of misses the point that the maps should actually reflect communities in a way that makes sense, and that there is a real subjectiveness that can and should go into the maps to be able to take those communities, to take communities that exist into account, and not simply sort of randomly, split people up or keep them together. And so, I think there was a challenge in sort of trying to elevate this point, which is, we stand behind 100% the analysis that Chen has done in this case, but you're now taking it out of context and doing something different that it was not built for. And so that was a challenge, trying to sort of communicate that. And so basically then the court said, okay, well, you can use the Chen map as the base map so that there's a starting place, and then tinker around the edges, as opposed to starting with the existing unconstitutional map and tinkering around the edges. So, it made the remedial process really limited in sort of what we were able to do, because it was just these sort of like, they sort of chose randomly out of the top 5 based on certain scores within each cluster. And so then there was just only so much that could be done from there.
Yeah, I think that's a really good point, is that a map could be, drawn on purely neutral redistricting criteria. And I'm not going to talk about the sort of complicating factor here of the county groupings, because that's like a whole other thing. But like, you could have that, and it still is not like a fair map in terms of fairly representing the people who live there and the communities that are there. Like, I think that that's a super important point, because I think people do, you know, I feel like I do often encounter people who say like, well, why don't we just have an algorithm draw all these maps and then we won't have a problem. But, you know, if that algorithm draws a map that still, say, splits North Carolina A&T in half, that's still a problem. Even if it was the computer that did it, you're still creating like an inequitable situation. So yeah, I think that's,
yeah, I always like to say redistricting is part art and part science. So you cannot just leave it to the science. You have to have the art too.
Yeah, yeah. And I think that another thing too is that, you know, so they started with these Chen maps, and then one of the main things that it looked like they were doing in the process, I mean, the actually a lot of the focus in the process to me seemed like they were taking these Chen maps, and the thing that they were correcting for was like incumbency, right?
Yeah.
They weren't like going into these Chen maps and saying like, oh, this splits this municipality and that's what's the problem here. The problem that they were looking to solve a lot of the time seemed like, well, you know, like this person's getting drawn out of their district, so, or they're being double bunked with this other person. So that's the real problem we need to try to solve in these Chen maps. And that was something that the court allowed, that came out in the court order, that incumbency was a factor that they could take into account. And I was just sort of wondering what your take is on like that whole issue, because it does show up a lot as sort of something that people think of as neutral.
Yeah, you know, we struggled a lot with that. I think, you know, it was sort of in a strange position where we'd won the case, but we were sort of like, but we don't like this like little piece of it here, you know, that you've done. So, you know, we obviously weren't going to appeal our own win. But I think, you know, in a perfect world, I think that allowing incumbency protection did, you know, as you say, sort of limit what we were able to do, and also, you know, in terms of getting what we were able to accomplish in terms of a more fair remedial map, and did sort of, you know, sully the waters a little bit in terms of, you know, we've like achieved this anti-gerrymandering victory, and then it's like, but you can still like take into account the politicians, because that's important, you know.
Yeah, the people who have been elected from the gerrymandered maps get to stay.
Yeah. They get to stay in their districts.
Yeah. So yeah, I mean, so, you know, at the end of this process, we have new maps for the 2020 elections. They are, I think, by most accounts, better than the maps that we had previously. You know, slightly less extremely gerrymandered, but not perfect. Clearly, they're resulting from the process that we've talked about, this like kind of imperfect process. So sort of what happened there, I just kind of want you to talk through, like, you know, we go through these redraws, we come out with these maps that we're not like maybe the goal that you all had in mind. So what happened? Like, why are we using these maps for 2020?
Yeah, you know, we made a very limited appeal on the remedial map, you know, trying to acknowledge, you know, trying to sort of accept the court's methodology and process, and just, you know, point out where there were really egregious, you know, problems going on. And ultimately, you know, the court accepted the remedial map. And, you know, I think it wasn't perfect, you know, and as I mentioned, you know, this all sort of happened in this really intense 3-month period in the fall of 2019. And, you know, and so we were doing the remedial process in the state, and then we filed the congressional case, and then we did the remedial process for the congressional map. And you know, so this was just like happening one on top of the other. And I think ultimately the court, you know, I can't remember, I think it was Judge Ridgway who said, you know, at the hearing in early December over the congressional map, you know, trying to decide whether or not we were going to continue moving. And, you know, he said something along the lines of, you know, we've come a long way in 90 days. You know, it's not been perfect, but it's been, you know, an incredible step forward for North Carolina. And so I think, you know, that, and I think that the sort of options other than, you know, the sort of alternative to accepting things at that point was, you know, upending the primary calendar, you know, sort of doing a lot of disruption to the election schedule in order to try and, push things a little bit harder. And, I think that the court was just very clear at that point that, they were sort of saying, we know that this is not perfect, but it's a vast improvement. So, everybody, let's just like take a breather from here, and you guys can keep fighting on the other side of this, on the other side of the 2020 election. So, I think at that point we sort of read the room and understood that the court wasn't going to really take us much further for the 2020 election. And so, but it, we have a lot of, we built through those cases, obviously, better maps than what we had, than what North Carolina had, but also, these building blocks for making sure that we are getting fair maps in 2021.
Yeah, so can you go into that in just a little bit more detail? Like, what do you think is going to look different in 2021 than in past processes because these cases happened?
Yeah, I mean, I think it depends a little bit probably on the makeup of the legislature, but I think certainly we're going to see nods toward transparency, but again, wanting to be, I think from our perspective and from your perspective, I and I don't mean to speak for you, but I do think, there's a lot of concern that that there is going to be sort of this show of goodwill, this show of transparency, without actually making that meaningful in any way. And so, I do think it'll look different. And it might look more like the court-ordered process, but what we really need to sort of make sure and hold folks accountable to is that actually the result is fair, and also that it's not simply a facade, that it is actually meaningful opportunity for public engagement.
Yeah. I mean, I think that's right. I mean, honestly, that is like my biggest fear, is that people are going to sort of see this kind of facade of transparency, but that there's just going to be the element of actual public input and people actually having effect on these maps lacking. So I think for my last sort of formal question then, what can people do when they engage in the process next year? Like, what is sort of from your perspective, like what is one of the most effective things that they can do, assuming that, we're going to have maybe some, we are going to have some opportunities for public input?
Yeah, I think that it's just important for people to be heard. And, if you have a sense of what your community is and how it should be kept together, or how you might be different from people that you've, other folks in your district that you've been kept with that are, doesn't make as much sense. If there are views that people have about how their community should be districted, how it should be included or excluded from other communities, just to speak up and to communicate that. I think, making sure that the public is heard in this way, and that there are, communications from real people who want to make sure that the legislators don't just get to say like, oh, well, it's important for this community to be with that community. Like, well, do the people in those communities actually think that, And so I think having that record of folks, coming through and speaking up and communicating what they need and what they want, and not everybody's going to get what they want. This is, it is still the nature of legislation. There will be compromises, and there will be, things that don't shake out the way, in a way that works for everybody equally. But that's different from, this is overall an equal, a fair process that represents communities in the, as best as possible. Within the limitations, and of drawing districts that are contiguous and that, that are relatively compact. And so I think, redistricting is an art, and it's a balancing act, but we can't balance people's needs if we don't know what those needs are.
Yeah, definitely. And that is like one of the main objects of the redistricting leadership course, obviously, is to give people the kind of background and the information that they need to do that, to make those kind of relevant comments about what they want for their community. So thank you so much, Marina, for being with us. This was super interesting. Even for me, like having been through this process, like it was really cool to get to talk through it with you again, because so much happened. It was really, and it was this huge event that really it's going to have changed a lot when we look next year at what's happening. So thanks again. Thank you to everyone.
Thanks for having me.
Yeah, and thank you to everyone in the program for listening, and I will be seeing you all again soon. Right.